Any mention?
Yes.
So far as is concerned, with the consent of Dr. Mazika,
Yes.
on my health grounds, I seek an accommodation, my lord. May I pray, if your lordship permits,
Yes.
could it be on 19th? Before the vacations, the matter can be finished up. The lordship has heard the matter on length the other day. I'm extremely sorry, on my health grounds, I could not. I'm having an eye problem, only eye pressure. If lordship permits.
It's all it has. 19th.
On 19th, my lord. 19th, my lord.
We do not know 19th how far it will be possible anyway. Okay. On the request.
Very well, mate.
On the request
I'm obliged.
made on behalf of the petitioner. This is matter on
Item 12.
19th. It's all.
Please,
Be
Lord.
obliged, my lord. Thank you.
Lordship, I beg to mention item number 9. I pray that this 9. That this matter may become up after vacation.
I'm for the respondent, Lordship.
No vacation. Okay. On the request made by the petitioner, list is matter after vacation. Number 9. Okay.
Highly obliged.
May it please your lordship.
Yes.
Mention item 16. This is that quashing application, your lordship. Which I'm paying for respondent 2 and 3 in this matter. I'm seeking
Yeah.
your lordship for respondent 2 and 3.
Who is the petitioner?
Petitioner is Mr. J. Shillai. Seeking a judgment on the ground that respondent number 2 has expired. Who is the complainant in that case?
Then need to inform the other side. Say like.
I've actually informed, your lordship. I've actually informed. Because the respondent number 2 has expired, your lordship.
There is no one. There are 4 no lawyers there. Just wait. What's the matter? Wait for the thing.
May I please, your lordship, I beg to mention item number 11, your lordship. Let this matter be taken after vacation.
Number?
11.
Yes, you're the petitioner.
Yes, your lordship.
You are petitioner. You are petitioner. You are appearing for the petitioner.
Yes, your lordship.
For 12 also?
Yes, for 12 also, your lordship.
Both the cases you are petitioners, isn't it?
Yes.
You are making a mention on behalf of the petitioner.
Yes, your lordship.
When? When do you? Yes.
After vacation, your lordship.
There is no private respondent here. Is there any private respondent, Mr. Sangupta, in this matter?
No, my lord.
And on the request of the learned counsel or the petitioner, this matters.
No. No private respondent, my lord.
Okay, 11, 12. After vacation.
Much obliged, lordship.
May it please, your lordship. Lordship, I beg to mention item number 5.
Item number 5.
Lordship. Lordship, I'm praying for 2 weeks accommodation, your lordship.
Who is the officer?
5 and 6 are connected, your lordship.
These are all 17, 18 meters. What is to be done? When do you want it?
Lordship, after 2 weeks, your lordship.
Hmm?
After 2 weeks, your lordship.
After 2 weeks. Who will see it after 2 weeks? Who will be there?
After vacation, your lordship.
Yes, Mr. Nangwe.
Don't know what to say. Asking for time repeatedly.
Nakma dispute. This is a Nakma dispute.
Headman, Gobra, and the other matters regard to cancellation of water.
Why these are shown as connected matters? Why?
It shouldn't be connected, in fact. But counsels are the same, appearing for the petitioners.
along with 59, along with 2004. But then it is showing that it is connected. Order has been passed. Definitely.
That order was posted for Honorable Justice. Thank you, Your Lordship.
Anyway, this one on the request made on behalf of the petitioner and not been objected by the counsel appearing with the respondents. And this matter after vacation. 5 and 6. Both will, parties are same in. I mean, the lawyers.
Are not same. Different parties.
But then the appearance.
Councils are the same.
Same councils. Okay.
Obliged.
May please, Your Lordship, I beg to mention item number 14.
Item number?
14, 1-4. I pray that the matter may be listed after vacation, Your Lordship.
I'm for the respondent.
Okay. On the request of the petitioner, this is the provision.
Obliged, Your Lordship.
Yes.
Item 16, Your Lordship.
You said there is.
Yes, I've come to learn also, Your Lordship, that he has expired.
Item 16, isn't it?
16. I would pray for some time, Your Lordship, in this matter, because I'll have to bring the death certificate as well before this court.
Okay, then. The respondent, you are appearing with the private number 2.
2 and 3.
And he says that it passed away.
Number 2 has passed on. The complaint.
Then what will happen? It is a criminal matter.
Will that be struck? Has to be struck off as a party from the instant proceedings. Substitution cannot.
Anyway, we are not having a death certificate, not holding a death certificate, isn't it?
Once we place it.
Take notice of the fact,
Yes,
and do the needful, whatever is
Yes,
needed.
yes, yes.
The court will not advise you what to do. You will have to do
Yes,
it by yourself. Okay. We'll just say on the request of.
Yes, yes.
We'll go after vacation.
Okay.
Just on the request made on behalf of the private respondent. Yes, state is also a party, isn't it? This will go after vacation. Yes. And the request made on behalf of the private respondents are not objected by the petitioner. This is made after vacation.
Highly obliged.
Yes.
Supplementary list, item number 1.
Yes, Mr. Movin.
Yeah, please, Your Lordship. Lordship is an application under Section 482, my Lord, for quashing under.
Quashing?
Yes, my Lord. The section level is.
How many quashing applications are filed nowadays?
Lordship?
How many quashing applications are filed nowadays? That way, nothing will remain with police. Huh?
Lordship, this is on basis of the compromise, my Lord. All the parties involved have settled the matter, my Lord.
326.
Lordship.
Grievous charge.
Lordship. All the parties are before this honorable court. This junction, I'm just bring that notice, my bishop.
You made complaint to party?
Yeah, all the parties, my Lord. Complainant, the victim, everyone.
This is joint petition.
Joint petition.
Joint petition.
Why joint petition?
Joint petition.
Joint petition, my Lord.
Why joint petition? How come complainant and accused come together and file an application?
Lordship is permissible, my Lord.
Which way will?
Lordship, I'll satisfy this court, my Lord.
No, there is no question of say like how do you know how accused and complainant come and become one party?
Lordship, they have
You
come
till
to
now, just because you have a settlement, does it mean that you become one party? Your status are different. You are complainant, one is complainant, another is accused.
But they have been coming, my Lord.
That is something.
Even in Supreme Court also they have been
Then
coming,
what
my Lord.
happens? Say supposing in cases like this, FIR is filed, investigation is conducted,
Lordship,
and subsequently parties come to compromise,
Lordship,
and on that basis, matter is quashed.
Lordship.
And what happens to the entire effort given by the police, the money spent, Who will take care of that? The complainant will pay.
No, my lord, but the entire
use the resources of the state for no reason. That is because of your act.
But the entire investigation becomes redundant.
Something has to be done, isn't it?
Once the complainant comes to compromise, my lord, with the accused.
That is so far as the closure of the matter is concerned.
Lordship.
But then what happens to the use of manpower, wastage of time? Who is liable for that? The matter has been investigated and charge sheeted.
Lordship.
So effort has been given by the investigating agency.
But Lordship also has to see that they have come to.
That is one of the aspects. That is okay. But then does it mean that it should go as continuous? Now many applications are coming like that.
Lordship. It has been accepted by Supreme Court as well, my lord. So that
part has not been taken care of. That has to be taken care of, isn't it? It should not be a matter of rule that you say like every case FIR is filed and after matter is charged sheeted at the stage of trial, matter is compromised, and then get it quashed before the court. That has become like a game.
No, but the thing is that, my lord, if they are if all the parties have come to a settlement, my lord, what is the point of proceeding with the matter?
See, so far as the settlement is concerned, Supreme Court will be definitely binding on us. There is no. But then what about that other aspect?
That other aspect has not been looked into.
Anyway, we'll issue notice, you take instruction. Yes. And take that part. You see, it is not proper that accused and complainant they come together. Make them other side. Why it should be thing? You see, like we do not know whether there is a duress or anything. We do not know. How do you know? If they are represented by the one counsel, the counsel will not speak against their interest of their own client.
So, but
how do you know?
Because of the interference of the Charles and Maris, my lord.
How we will know? That is, see, these are all versions coming from your mouth. It's coming from one mouth. You understand what this court is trying to say?
That aspect is looked into, my lord.
You see, we do not know what is this coercion, or you see, like which way this settlement has been arrived. So, if it comes from one version, we will not be
from the same village, my lord. You want to live peacefully among themselves.
That is what you say. Does it mean that in the same village, even neighbors they fight?
Otherwise, Lordship, he says, is with the intervention of the Charles and Maris. The Charles and Maris should have been made party.
You see, if you want the quashing of a matter on the basis of settlement, then court must be sure that there exists a genuine settlement, which we will determine the genuine settlement.
Then Lordship have to call the parties then.
Definitely. That if required, then we'll have to. We have to.
This is not a code of evidence, my lord. That is why.
It's definitely see, but then if the court for satisfying, it can call the call.
But what is the problem, my lord? If both the parties are coming to a settlement, my lord, and like they want to.
How do you know that is a proper settlement? You know it. How the court knows it? That there is a real settlement. How do you know that this settlement has been obtained under this thing, threat? Whether it is obtained under threat or not. How this court will determine? See, so for you, you know it. It may happen like that. The complainant is threatened, and by force once the signature is obtained on one settlement, and then subsequently the entire case is presented through one lawyer. How this court will determine that situation? State also will not know that.
Lordship goes
if it becomes a practice, if it becomes
like that, my lord.
See, if it becomes a practice,
quashing at all, my lord. If that be the case, my lord, then there cannot be any quashing at all, my lord.
Why not?
No.
See, why not?
Quashing is coming, my lord, because of the settlement, my lord. In most of the cases.
How do you know this settlement is genuine settlement? Which way this court will determine that?
Lordship.
How? Just say. How do you know this settlement is not obtained under threat?
No,
it may happen like this accused herein. Just how? Satisfy us. Tell us.
No, if
this court is doubting. This court is doubting because since a complainant is accused is represented by the same counsel, the court is doubting the settlement. Now we satisfy the court that this is a genuine settlement. How we will do it? The only option is that we have to call the parties. Give us any other way.
Well, I'll try to satisfy, my lord, by bringing Supreme Court judgment as well, my lord.
The Supreme Court says that can be represented by one
No, but it has been represented by same counsel, my lord, in the Supreme Court as well.
Is it?
Yes, my lord. I'll try to satisfy this honorable court, my lord.
Please show it to us. 2019, Madhya Pradesh case.
I'll try to satisfy, my lord.
Anyway,
Lordship.
Mr. Ejimomi. It is not very encouraging that they should come by one counsel. What the court is pointing out right now is that court is not saying that there should not be a settlement. The court is saying that when there is a settlement between complainant and accused, at least they should be represented by two different counsels.
I'll try to satisfy, my
lord. Mr. Ejimomi, learned counsel for the petitioner, issue notice. Be returnable in 3 weeks. Who will accept? Mr. Kharmi?
Yes, Lordship. I'll accept it.
Mr. Kharmi appears on behalf of the. There's only one respondent.
No, sir. One respondent.
On behalf of the sole respondent. As such, no formal notice is called for. List is met after 3 weeks.
No, Lordship.
Hello, Lordship.
See, think about that part. You see, it is not that this court is opposing to your application. This court is opposing. See, court is not taking any stand.
Lordship.
But then these are the things we should take.
Lordship, I understand, man. I'll try to satisfy.
It may happen like this. If tomorrow state takes a contention that there is no settlement, then what happens? How will satisfy it? How will satisfy it?
Lordship.
Just because you produce a written document before a court, purportedly to be a piece of compromise, may not satisfy the court.
Lordship.
You have to think about it.
Hello, Lordship.
Daily list, item number 1.
Matter, I have taken a step to issue notice to the private respondent, Your Lordship. This service is still awaiting, Your Lordship. I have checked it from the net, but they have not shown that it's been delivered. It's under process. Yeah, I've served the notice to private respondent port.
No, 6 has been, respondent number 6 has been received.
Lordship.
That is what the office note says.
Lordship.
Who is respondent number 6?
Respondent number 6 is Nokuma, Lordship. Gujan M. Marak. Then another is Pilon Chets Marak.
Nobody is appearing for respondent number 6?
No. I'll check and file the affidavit of service.
What is this matter about, Mr.?
This is the case where I filed the FIR because
the poaching of
yes, poaching. Yeah, register.
On the previous occasion, Mr. Khan appeared.
Lordship.
Yes, Your Lordship. Today he is not available. It's in his operation.
What do you say about?
Lordship, in fact, in my humble and respectful submission, it's too early, Your Lordship. It's premature. It's premature, Your Lordship.
See the accusation under what section?
Police.
It's for him, Your Lordship. I'm not going to.
Yes. All right. Well, office note dated. Well, Mr. P.T. Sangma did not argue that part.
It's for him, Your Lordship.
Neither there is a reflection of the same in this sentence.
Lordship, I have to prepare on the next.
Of course, he knows the indication. On the last occasion, when Mr. Khan was appearing,
now I'm aware,
indicated that part. The problem is that if something comes to the notice of the court, irrespective of the fact whether it is raised in the hearing or not, the court has to give, you say, like, goes to deliver of the things. You say, like, you cannot ignore it.
Lordship.
So that is a part which you have to counter whether he raises it or not. The office note dated 5/12/2023 indicates that notice upon respondent number 6 has been duly served. However, in respect of service of notice upon respondent number 4 and 5, the same has give a comma, the same has not been received. What shall we do? Shall you?
I will just get from the post office. I will inquire.
Achha.
If required, I will
Mr.
file
P.T. Sangma, Lord Counsel, but the petitioner submits that he may be allowed to verify the status of service of notice in respect of the
4 and 5.
Respondent number 4 and 5. And affidavit to
service,
that.
Lordship.
Come after vacation, Your Lord.
Prayer allowed. List this matter after vacation.
Apply.
Hearing item number 7.
Yes. Have you filed affidavit?
Yes, Lordship, we have already filed.
Where is Mr. Dr. Majik?
He's on next, Lordship.
My lord, we have to revert this affidavit. We have to revert this affidavit.
Revert? You want to? Why? What has been stated here?
My lord, they have said that no GD duty is given, whereas he is performing the general duty.
No, but then if does it make any difference? The fact remains that you are retained in service.
Retained in service and doing the...
Whether duty is given or not given, which way it becomes a material?
Definitely, my lord. And the plus, my lord, nothing where they have, after fresh medical board, nothing has been annexed, my lord. That remains silent, my lord.
That is all right. That will become a question of marriage.
My lord.
That may be a point in favor of you.
Definitely, my
but
lord.
Then is it required that you revert it by filing an affidavit?
If
It is required. See, if it is not required, then unnecessary, this basically filing of so many affidavits makes the file bulky and serves no purpose.
That since that is only the crux of the matter, my lord. They say that they have been given a shelter appointment and not performing the duties.
Okay. So, Mr. Arja, this is how many cases are there?
7 and 8, my lord.
All these are same. Both are same.
Both are same.
Affidavit has been filed in both the matters. Same order was passed.
My lord.
So it can be covered by one order. Mr. Arja, Honorable Counsel appears for the petitioner. Pursuant, just started this. Pursuant to the order dated 28/3/2023. An affidavit has been filed by the respondent bringing on record the subsequent developments which took place in the matter. Stop. Mr. Arja, learned counsel for the petitioner, submits that the affidavit filed on the petitioner desires to file. What shall we say?
A rebuttal, your
a rebuttal to the
said debate.
Averment made in the said affair and prays for grant of some time. Prayer allowed. It will go after vacation.
As your
It
lordship.
will not be possible. See.
As your lordship wishes.
But you want it next week. But then,
my lord, as it is, my lord, hearing has to be done, my lord. Definitely, my lord. Let it come after vacation. No.
Prayer allowed. List this matter after vacation. The meanwhile, petitioner may file his rebuttal affidavit in the matter.
Both the matters, my lord.
Both the cases, same order.
Same order.
Okay. This is 7 and 8.
7 and 8. Yes.
Item number 13.
Yes, Mr. Bora, what is this?
May I please? Well, as I said earlier also, I'll come with the FIR. I mean the Caesar report which was treated as the FIR and the case had begun. I got it typed. Hello.
What is the matter about?
My lord,
this is a revision under section.
I'm accused as in a case, NDPS case number 15 of 2020, where a seizure of contraband ganja has been shown from a vehicle which is owned by me.
My lord,
yes.
I may just inform this court lordship about the case at the trial stage. The matter was fixed on 5th of September 2023, and the accused has been issued with a bailable warrant, lordship. I just want to brief this honorable court before my friend starts.
No, you're not
yes, that is true. And he appeared in the court and got a permission to stay in his previous bail. He appeared in the court. And next date fixed is on the 8th of January. Proceeding of 227 is there.
This is not.
Because if accused is absconding, this court will not hear this application. That is for sure. It doesn't mean that he should run away. But then if you say that...
So the matter may come after 8th of January because the matter is fixed on 8th January in the law court.
That will be better. Then not 8th of January, then it will go to February.
We'll wait till...
Okay, but then make sure, if accused is absconding, court will not entertain.
Yes, my lord.
Okay.
After 8th January, my lord.
It will come in the month of February.
Yes.
Much obliged, Lordship.
Yes. With the request made on behalf of the petitioner,
Obliged, Lordship.
this is matter after vacation, after winter vacation.
Item number 50.
Obliged, Lordship.